But what you're telling me is, if it's possible that this prisoner has to go through the expungement process, and there are procedural bars from doing that, there is no remedy for him or her in order to secure their rights even 20 years from now. What you're basically saying is, simply because they've been previously convicted, they cannot seek prospective relief 20 years from now, unless they get an expungement. But if they're barred by some procedural reason, they have no protection.
A few limiting principles on that, Your Honor. We certainly draw the distinction between a properly lodged as-applied challenge and what the plaintiff is trying to do here and make a facial challenge, a prospective claim in name only, which is really by way of a declaration, where he would want the entire law declared unconstitutional.
He might win. He might lose because it's a facial challenge. We'll find out. But the question you're saying is he is going to be barred.
Unless and until he is able to achieve a favorable termination.
How do you deal with Edwards? How do you deal with Edwards remanding for the prospective relief to change the disciplinary procedure?
So certainly the language in Edwards is ordinarily a prospective claim would be barred, would not be within the ambit of HEC. We're very comfortable with the ordinarily language because ordinarily does not mean always. And if there is ever a situation there where
the procedures that he was attacking were the same ones that he raised in his past disciplinary proceedings, so I don't know why Justice Scalia wouldn't have just ruled.
Well, as I understand, it was the date stamping procedures, and it was unclear in the case whether or not those date stamping procedures had actually been applied. And even if they had, Justice Scalia would say you apply the test. And it's either a thumbs up or thumbs down determination. And if it's outcome neutral and it wouldn't result in a disavowalment or a collateral attack, then that's okay. But in this particular circumstance, there can be no greater impugnment on the prior conviction than a declaration that the law was unconstitutional.